that Section 43(2) of the Judicature Act, Section 43(2) of the Judicature Act, provides that where there is no procedure laid out for the High Court in any written law, where there is no procedure laid down for the High Court by any written law or practice, the court may, in its own discretion, adopt a procedure justifiable by the circumstances of the case. That's what that provision says. This provision refers to the High Court sitting and a matter of procedure arises and the law is not clear to that judicial officer. Then that High Court judge will then, in his seat, exercise discretion as the circumstances of the case warrant.
Just put it clear that I'm sitting in the chief of court.
My Lord, I prefer using my words, and I do not want to put words in my mouth. We can say you're seated in a court of religious track, simply put. So, my Lord, Your Honor, the High Court is the one to make that determination in a matter of procedure. Now, receiving sureties in the instant case is not a matter of procedure. And it is not even the High Court receiving the sureties, exercising that mandate in itself. It's not the High Court, it's not a sitting judge. Because it is the sitting judge, the High Court, to exercise that right and power. I need not overemphasize, Your Honor, that matters of jurisdiction are creatures of statute. Matter of jurisdiction is a creature of statute and cannot be delegated, not even by an order of court. And it's not delegable or cannot be delegated, not even by an order of court. That would be an illegality. It's like the High Court telling the Chief Magistrate, handle a murder case. It's an illegality, ab initio. I would wish to draw court's attention to the case of Uganda Revenue Authority. Uganda Revenue Authority versus Rabo Enterprises Limited, Supreme Court Civil Appeal number 12 of 2004, where the Honorable Justice Lillian Tibatemwa Echirifubinza stated that registrars cannot exercise jurisdiction beyond their express Your Honor, I don't see you writing. Legal mandates.
On the microphone.
I pray it's captured even in your report.
Instantly, I asked
not expand. But it says, the court said, where the court held that registrars cannot exercise jurisdiction beyond their express legal mandate. The effect of this decision, and my Lord, Your Honor, I'll furnish court with a copy of the decision. At the rise of court, it's there online. Your Honor, it's online, so you can check it out. It's online. Your Honor, the IT specialist can confirm that there is internet in court right now. Proceeding. Most obliged. The judgment emphasized that any action taken by a registrar outside his or her bounds is null and void ab initio. And I already stated that not even an order of court can confer delegated powers. To that note, Your Honor, I appreciate to hear the sureties. I really appreciate. This matter has been adjourned severally, like counsel said. But in the interest of maintaining the integrity and legitimacy of these proceedings, it is in order that the law be followed. I beg your pardon.
I appreciate the express desire that I have express desire by the registrar. So I'm not acting under instruction, but it's my desire.
Your Honor, if you have, you can borrow me a better word. I'm trying to think, but I appreciate the express, your availability. I would. You know, I would wish to distinguish the court, the judge, and the court, the registrar, because that's now where the gist of the discussion is. I said this respectfully, Your Honor. I'm not trying to. I'm just concluding my prayers so that we get into. Yes, like I said, I appreciate the express availability to receive the particulars of the sureties in this matter. However, in the interest of maintaining the integrity of these proceedings and legitimacy of the application that has been filed by the applicant, it is only in the interest of justice that either the matter is adjourned until the availability of the judge to entertain it, or recourse can be sought from the head of the division or any supervisor to have this matter reallocated and heard by any judicial officer who is available. Otherwise, we shall suffer a fate, the applicant will suffer a fate where several applications will arise to be determined, pending even the determination of his own bail application. in regard to the legitimacy of the proceedings, it is the applicant that will suffer. I really want this matter disposed of as quickly as yesterday, but in the right way. In the right way. I so pray, Your Honor. Associates with my submissions. Maybe the clerk can first reiterate what I was saying before counsel stands to the applicant. We do it.
The applicant is duly represented by 6 lawyers. That should not be his worry. Your Worship, first and foremost, I am baffled by submissions of my land council and land state attorney, senior state attorney. Firstly, to note, Your Worship, is that the court is not making a determination in this matter. The court is not sitting to determine the matter. Those are very key, important issues to note. The court has specifically stated that it is here to receive on the sureties for identification as directed by the trial judge. Your Worship, I want the court to note trial judge. The trial judge is every known in this matter. And my land friend has considered every that the trial judge gave directives. Unfortunately, is not here either on health grounds or other grounds, and has issued a directive to that effect. It's unfortunate, it's baffling that my land senior state attorney, who has practiced before this court, cannot appreciate the administrative nature of these courts. Your Worship, has stated that section 15 of the TIA enjoins the court to hear bail applications in the High Court by a judge. We do agree that that is the position. However, Your Worship, you're not sitting. In fact, the courts, as near as possible, have always adopted a procedure to see of the Judicature Act Section 14(2)(c) of the Judicature Act. In circumstances where there is no proper procedure and the court is enjoined to promote good.
Can you read the section?
Most of
No, I was saying let's use off the microphone.
that section, Your Worship, is to the effect that where there are no express law or rule is applicable principles of justice, equity, and good conscience, the court is enjoined to adopt a procedure that aims at promoting equity and good conscience. Your Worship, the directive by the land trial judge is in conformity with this particular provision. And indeed, Your Worship, it has been a practice of this court where the court, under that particular provision of the law, directs the registrars to either identify or receive passports in case a bail application has been concluded, or enforce the directives of the land trial judge. It is in conformity with that particular provision. Your Worship, it is a fortified submission that you're ably in charge of the directive of the land trial judge. You're not sitting as a court to hear the bail application. And indeed, as the land state attorney has stated, equally enjoins this court, to give such directives in order to achieve the ends of justice. Your Worship, the land state attorney has relied on the case of Global Enterprises to a registrar to hear the matter. We disagree first and foremost. In the Global Enterprises case, Your Worship, the registrar entertained certain matters when he did not have jurisdiction. He had determined, and the Supreme Court said, no, you do not have such jurisdiction. This is not a matter where the court is hearing. This is not the matter where the court is saying the sureties are substantial. That is not there. The submissions of my land state attorney should have arisen at the time of an appeal, in case he wants to appeal, that you entertain. Your Worship, it is on that ground that we invite you to proceed and entertain the receipt of the sureties. My land colleague, Mr. has something to say.
May it please Your Worship, I'd like to emphasize section 43.2 and read it in verbatim, that talks about officers of court. And it states as follows. 43. That subject to Article 133 of the Constitution, the officers of courts of judicature shall perform such duties as may be assigned to them under the rules of court, and shall be subject to general direction and supervision. And also 43.1 states that there shall be such officers of courts of judicature as may be necessary in performance of any such special duties in connection with the business of courts of judicature. And such officers may include the chief registrar, registrars, deputy, etc. Your Worship, when we are here, state can also attest. Just a second.
I just want to get clarity of the provision, because the 43 is reading. I just wanted to be maybe clarifying that. We seem to be reading different laws.
It's clear here that where in any case no procedure is laid down for High Court, by any written law or by practice.
Council, what section are you reading? Because your colleague that wants to ascertain.
Section 43
Of the laws it is.
of the laws it is, Your Worship. And in any case, Your Worship, has adopted a practice in applications, and would like to say that you're seated here as court, not in your own capacity or from your own volition. And you stated that you're here to identify. In any case, we already made submissions that you clearly stated were already a record of court. And they associate themselves to those submissions, meaning, Your Worship, that even a judge, and you would say that that would be a fault in procedure. You're here in the rightful capacity, and we invite you to perform your duty as assigned to you as court. Most obliged.
Your Worship, just one thing, because the land state attorney relied on Bravo Enterprises. Of course, that was equally civil case, but this court equally is enjoined under Order 51 of the Civil Procedure Rules to entertain interlocutory application. Your Worship, we are not saying you're entertaining an interlocutory application, but this is an interlocutory application that you're equally mandated under Order 51 of the Civil Procedure Rules to entertain, because this is a bail application arising out of the main case. So, Your Honor,
I don't want you to read us, just because this
most of that. So, Your Honor, it is our submission that just like how the court gives directives to you to adjourn matters, these directives are in sync with you to receive the sureties that the court has decided. The trial judge has not divested himself of the powers to entertain and for bail. That one is not Secondly, the trial judge has not directed you to determine the substantiality of the witness of the sureties. The trial judge's directives are very clear. Receive the sureties. And Your Honor, that is the normal duty that everybody should be in position to appreciate. First and foremost, the documents are already on record. In regards to the sureties, the land state attorney replied to those documents. What is here is specifically to identify the sureties that the court has never had occasion to look at. Your Worship, if you so wish it, but I don't think that it has.
I'm most obliged, Your Honor. I believe the submission that this Honorable Court under Order 51 of the Civil Procedure Act has powers to entertain this application. Your Honor, it was on record. I pray to make response. Well guided, Your Honor. Your Honor, this matter has been captured on the record. Your Honor, I don't mind that you don't report it, but I told you that I still bring it up. Most obliged. My brothers submitted that This Honorable Court, by Order 51 of the Civil Procedure Act, has the powers to entertain this application.
That's what he's saying, but saying interrupted application, I notify that this is an interrupted application. Okay?
My Lord, it's actually the same argument.
It is overruled that this court cannot entertain interrupted application to do matters. Proceed. So I have ruled with your application.
And on that overruling, on that ruling, this is an interlocutory application. The bail application is an interlocutory application. And as court has rightly ruled that it does not have power to entertain, sure, it does not, and I agree with it. My brother has continued to submit that the court as it sits now is merely hearing, not determining the application. But that's not what it is. Your Honor, the court is receiving, Your Honor. The record is clear. We can always get a certified copy later, and we shall know what each person said. So my brother has argued that this court is merely hearing, not determining. And he further stated that the court is merely hearing from the sureties who are already on record. How can court determine if in the first place there was no hearing? You know, just the thought of it, it doesn't make any sense. By this court as it's sitting, receiving the particulars of the sureties in the record, that in itself amounts to hearing. Whether it determines the application or not is something else. And that is the integrity of this application that we seek to have maintained. The entire process of it. By hearing the sureties, getting their name, getting their residence, getting their phone number, getting their national ID details, that in itself is tainting the application in its entirety. And we want to arrest that abuse. And there is no doubt, once an illegality is brought to the attention of court, court must not close its eyes to it. My senior brother, the Honorable Mwizerwa, said that I had said, and I wrote him verbatim, that I had said that this court has in the past adopted the practice in applications. I did not make that submissions, far from it. And there is no practice I brought to the attention of court that has been adopted before. Your Honor, there is a very big difference between a registrar appearing in a matter such as this and adjourning, then appearing in a matter as this and receiving particulars of sureties. When a registrar sits at hearing the matter, but when he goes ahead to entertain and get information that informs the determination of the application, that is a hearing of the matter. Which cannot be tolerated by this honorable court. A section was read, section section 14.2c. And I would first want to read it verbatim and I make an explanation thereafter. So section 14.2 says, subject to the Constitution and this Act, the jurisdiction of the High Court shall be exercised A, in conformity with written law, including any other law in force. Then when we jump to C, we cannot say these proceedings are proceedings of the High Court. They aren't, as far as this provision is concerned. So this refers to the High Court sitting. And it says that the principles of justice, equity, and good conscience. What does justice require? What does equity require? What does good conscience require? retaliate my earlier prayers.
kooti egenda mu maaso.
I'm a little small of you. Above all, I have looked at the law as cited by all counsel in this matter. I got instructions. limited to identifying sureties whom the applicant proposed to quote from the trial judge. This is linked to the administrative function that registrars are clothed with. Identifying sureties is to compare what is on record already as sureties with the actual persons in court. This practice has been long in place. It's not an invention by the trial judge today in this matter. To require a registrar to conduct identification of sureties. It's one such aspect that occupies registrars and that occupies the one is sitting as a registrar. Quite some trouble. This is done not only in application for bail, but also in the application in administration causes where applicants are seeking for letters of administration. Neither is a registrar closed with authority to grant letters of administration or hear such an application, just as in bail application. Yet in all instances, the trial judges have often authorized registrars to conduct identification. In my view, the identification of sureties does not amount to a hearing of an application, because the sureties have already been identified in the pleadings and in the submissions. There is no illegality that is being condoned, which is clear by the prosecution that was calling this application. It is a practice that many courts, for example, had in accordance with section 43 was conduct identifications. Now, the role of this court here aims at satisfying court that indeed what was recorded by court under the pleadings, that's the notice of motion and the applicant, and the submissions is what the applicant with all the above said, this court proceeds by identification of sureties in this application conducted. I so order.
Most obliged. Most obliged, Your Honor. Your Honor, I just needed to go on record that I intend to challenge the ruling of this honorable court. I just want that to be on record. Most obliged. Your Honor, will require a formal affidavit that has been directed by the ruling of the court. Proceed to identify the sureties that under the first surety, Mr. Mkasa Yusuf, where you please come forward here.
abo be balina okweyimirira Hajji bamulaba bajja. Saagala mugambe nti bagenda muwa bail. Mucamuke mpola. Bazze bakubye yunifoomu ya bbulu. Microphone.
Wenga abanya oluzungu babakkiriza.
Beebo abavuddeyo okweyimirira Hajji naye kubawulira buwulizi si kumuwa.
So that's the order.
Yes, that's the order. Is the Mufasa Yusuf as the first surety under paragraph 8 of the affidavit. Your Honor, all the documents in respect of those sureties have been submitted to court.
Counsel, are you watching the...
My Lord, I request that counsel pass with the correspondence regarding Your Honor, the documents for Mr. Mufasa Yusuf were submitted.
Oyo ye maamu okuva ku muzikiti e Mutungwe bw'asaalira ate neiba.
We pray that the court identifies Mr. Mufasa Yusuf and takes him as a surety for their software for the industry. Maybe just to state your honor, the national ID for the applicant is on record. The LC letter, Kulenga Bill for Council 1 is also on record. Your Honor, I would also like the court probably to look at the original national ID of Mr. Mufasa Yusuf, compare with what is on record.
This one, counsel. What is that for now?
Tukira namba yesimu 0772 60 2962. Mr. Mufasa. Applicant is only able to submit on Hajji. He's a friend for 20 years.
esinga nnyo kuba obusuubuzi bazirise era wanikuyitiki ngaayogera omanyi singa wayogera ebiyo egenda kuba
That is the position, Your Worship.
Mukuru Mukasa. Mukasa. Tutegekeddwa kugenda mu kkooti n'abagamba nti